And with that, I will call the case, which is Canty versus Mason. This is a mini oral argument on the application, 15 minutes per side. Mr. Stone, if you want to reserve some time for rebuttal, you may. We just ask that you keep track of it for yourself. And as always, there's a 2-minute fire-free zone that you can waive if you'd like to.
Thank you, Your Honor. Never heard of fire-free zone before, so I will waive that.
People call it free fire, but it's actually fire-free. Yeah.
Fire-free zone.
Who knew?
I'd also like to let the court know, I'm a litigator, very nervous today, never been in front of this court, so if I mumble, I apologize. I'd also like to thank the audience today, and if the court will take notice, there's the sides that they're on does not constitute the sides I hope this comes out on.
It's not like a wedding, it's okay.
Because they outnumber me on this side. Thank you very much. Today we're here to talk about opt-out Medicare fee schedules. I'm going to start by saying my client opted out, meaning PIP does not apply. If you opt out of something, you're done. Those rules don't apply. He opted out under Part A and Part B of Medicare. In 1980, we have a federal statute that doesn't allow for Medicare to pay for automobile accident injury claims. That is in use today in the state of Michigan. We have first-party benefits, and we have third-party benefits, and now we have an opt-out benefits. Under first-party benefits, Medicare never comes into play. So what has changed? Nothing. Medicare is still the supreme statute that holds. Medicare in Part A and Part B are only there for if there's no other recovery under the Medicare statute. And this Medicare statute says liability insurance is viable, so Medicare won't apply if you read the statute. So what happens here? My client goes to a Medicare facility. They don't bill Medicare, or maybe they do bill Medicare. But Medicare doesn't apply. If they bill Medicare and say it's an auto accident, then they're committing an act that shouldn't happen. In the statute, it says, without limits, allowable expenses go to the third party. The fee schedule, and let me back up, I apologize. Our fee schedule under MCL 500-31572 is for, that's the fee schedule, what a fee schedule applies to, for additional bodily injury covered by personal protection insurance. There is no, so it only applies to personal injury protection insurance. That's what's in the statute under number 2. It doesn't say for third parties. It says payable by personal injury protection insurance. He opted out. Personal injury protection insurance doesn't apply. So if it doesn't apply, it can't be held on the third party case. The next phrase, it goes without limits for allowable expenses. This was added to the statute because under Part A and Part B, without limits for allowable expenses gets transferred to the third party. Well, what changed? The first part of that says between 3107 and 3010, you get 3 years past wage loss, it flows over. 4 years ago, 5 years ago, there was no fee schedule applied to that. Today, there's no fee schedule applied to that. When it says flows over without limits, what does that mean? They want to say something. I want to say everything goes over. We don't know. The statute says without limits. How do we determine that? Do we do textualists? And Judge Czar is big on that. Do we take the words word for word? That means everything flows over. But I, again, go back to the statute itself.
Counsel, I want to address the first argument, the mitigating damages.
Oh, sure.
So you said earlier that had the providers billed Medicare, it would have been illegal.
Yeah.
I don't understand what you mean by that.
Because just like Medicaid, when you go to a doctor, Medicaid won't bill for auto accidents. Medicare shouldn't bill if it's a result of the motor vehicle accident. If they put
Well,
auto.
they're not a primary payer, correct? They're a secondary payer. They're secondary if there's auto or liability coverage.
In an opt-out situation,
Well, this is what I'm asking, I guess.
they're never they would always be secondary, correct? They're always secondary.
Okay, so had your client gone and the providers billed Medicare for, assuming, and it appears that it's questionable, some may have billed for some circumstances.
Correct.
This is something to be worked out below. But had they billed Medicare and Medicare had made a conditional payment, right?
Correct.
And asserted its lien, it would not have, because it would not have been a collateral source, right?
It would be a collateral source.
Under
In the
the
third-party
statute, if
case.
they asserted a lien?
Yeah, if, in the third-party case, because it was already paid. That's what our brief, so it would be a collateral source in the third-party case.
Even though
What?
Medicare asserts a lien. I thought that the collateral source statute says that they're a collateral source, but if they assert a lien, then they're not considered they're
I'll
not
take
considered.
your, that's fine.
Okay.
Well, then how do you reconcile the fee schedule? Because these doctors aren't being even paid fee schedule or above.
Right, well, I think the fee schedule can be, I mean, I get that they're somewhat related, but the duty to mitigate damages, a third-party claim is a tort claim like any other tort claim, correct? Where the duty to mitigate damages
Yeah.
arguably applies, right?
Sure.
Okay, so if your client didn't, the only way that they're not considered a collateral source would be is if Medicare had asserted a lien, but if they were never billed, there is no lien. So so they would be a collateral sourse.
Correct, the bill would then go to the
So
third party.
if they're a collateral source, what Medicare would have paid, or what's payable by Medicare, why is that not the same thing as saying that you had a duty to mitigate those damages?
Because
on the
duty
front
to
end?
mitigate those damages in that position is to duty to mitigate the tortfeasor's negligence or their duty. I, as a person with Medicare in Part A and B, can go to a chiropractor, okay? That chiropractor might not take Medicare. Am I then mitigating my damages? Under their statute, no, because now I should
Well, but
automatically bill with Medicare.
I don't think that's what the Court of Appeals says. The Court of Appeals opinion says that if they accept Medicare and could have billed it but didn't, that those what Medicare would have paid were damages that should have been mitigated. Now, you may still be able to argue to a provider that didn't accept Medicare and didn't bill it, and that was still reasonable and necessary, and a jury can decide that. But I believe the Court of Appeals is limiting or is talking about the duty to mitigate with respect to benefits that could have been paid by Medicare.
What allowable expense then, when it says with or without limits, would flow into the third party if Medicare was billed? There wouldn't be any. So that phrase is null and void, because all the medical bills would be paid under Medicare. Nothing would flow
Counselor,
through.
can I put some numbers on this just to help me understand what you mean when you say mitigate damages or that you don't have to mitigate damages? So imagine there's an injury and for two providers, and one provider is not a Medicaid provider, that's independent, it's a reasonable team, and that provider charges $50. And then there's another provider, which is a Medicaid provider, and that provider is charging $75. So we've got $125 in medical expenses. Medicare is charged, and they satisfy that $75 bill for $50. So is your position that the plaintiff can seek $125 regardless of whether or not Medicaid pays that? Your position is there's no duty to submit that to Medicaid, and then you can seek the $125? Are you just saying we can seek the $100 and then Medicaid care is going to be reimbursed that $50 that they paid out? Help me understand.
It's actually both. I guess it's up to the business owner what his risk is, right? He's taking on this patient. So if they want to bill Medicare, then you would have the Medicare charge of the $50, and they could get the difference in the third party. Or if they do that, if they don't, they can get the whole 150 or whatever your number was from the third party. However it is, but it's their risk. They're treating their.
But does your client have to at least try to submit to Medicare? And whether they pay or not isn't their, that's not their choice, but are they obligated to submit to Medicare?
Is my client
Are
obligated?
they, if they go to a Medicare provider, they can't get in the way of that being billed to Medicare?
They can't, but the provider. See, the statute doesn't say you have to even go to Medicare. It just says you're eligible for opt-out. Doesn't say you have to use your Medicare or Part A or Part B. It just says you're eligible for an opt-out.
So the opt-out provision, you can opt out if you have qualified medical care, and that could include Medicare Part A and B.
Correct.
Or it could include health insurance that doesn't exclude auto accidents, right?
Correct.
And so if I opt out because I have health insurance that doesn't exclude auto accidents, are you telling me I wouldn't be obliged to use my health insurance if I got into an auto accident and had to go seek health care?
Again, you're free to treat with whoever you want. You could go to a chiropractor that doesn't take your health insurance. You go to a PT person, or you could go to 4 orthopedic surgeons and say, hey, you don't take my health insurance, but you do, but you're way better.
So counsel, but the legislature was really clear in 2019 when they did this massive overhaul that the reason they could reduce sort of premiums for auto insurance was we're going to look to the health insurance industry instead. Now, maybe you're right. Maybe people can go out of network and have that debate if that's reasonable. But are you real? I mean,
No.
why would we not treat health insurance and Medicare the same?
Health insurance is different from Medicare, because Medicare has a statute that says we're not paying for it.
I understand it's secondary,
Okay, so
but is that
they're
what the
not the same.
legislature intended when they drafted the law? I understand we could have a debate, I suppose, about federal law and whether all the states' systems are valid or not, but it seems like the legislature was pretty clear what their plan was you can opt out if you have health insurance or you basically fall under Medicare. So-
Correct, but the mistake they made is Medicare is not a primary.
So everybody who's over 65 who is opted out basically is free to sue without limits in tort? That's your
what
position?
opt-out is, correct, without limitations.
You would
That's-
acknowledge that would be pretty disruptive to the system that our legislature set up?
No, that's the way it's set, that's the way it was set before, except it had limitations, it couldn't go past 3 years. Or let's say the PIP policy was a 250 policy, and the next $1,000 to and they're catastrophic. All that money flows to the third party.
Can you, in your view, and I will ask Brother Counsel the same question, can you explain to me why the legislature would have intended to treat first-party claims different than third-party claims as far as reimbursements? Like, I understand,
I have no idea what their reasoning were, because this law is very poorly written. So no one can really tell what their state of mind is when it was written. There's so many other bad parts to this law that we could go on for days. But with regards to this, 3157-2 says only applies to personal injury protection insurance, and there's no personal injury protection insurance in the third party. They believe the fee schedule applies because 3135 references 3107 and so forth way down the line. That's not true. Nothing has changed from our first party benefits. If you got in a car accident and you had Medicare, Medicare in first party is never responsible. The insurance companies put on their coordination of benefits, Medicare, do not bill Medicare. So what changed in opt-out? Nothing except, nothing changed. They just eliminated the order of priority. They didn't change the law that says they're not responsible. Medicare is not responsible.
So then why not just draft a statute that says, doesn't even, if you're over 65,
They should have. They should have put the words in here, fee schedule applies to the third party. They should have put a lot of stuff in here. They didn't. And that's why we're stuck without limits to allowable expenses. That's what we're stuck with. And to say that means
Well,
everything flows through.
I mean, there was a change prior to 2019, the statute to sue in third party, your medical expenses, unlimited medical expenses, because nobody had an option to choose less, your medical expenses were paid for. So you were suing in tort for excess economic damages and non-economic damages.
Not all the allowable expenses weren't, you could claim the difference in the
Okay,
in the bills
so
to the third
so
party.
that is the difference, though, of then if you no longer have to get your PIP benefits through your insurer because you opted out of lifetime medical, you don't have this excess or over, I mean, isn't that what the without limits is talking about? Not really the fact that in a tort action, you still have to mitigate damages. And if you never asserted, if you never submitted and received payment from Medicare, there is no lien, and those, what Medicare would have, what was payable by Medicare would have been a collateral source that defendant's liability is reduced by. So if it gets reduced at the back end, why is that any different than saying that you had a duty to mitigate those damages by actually seeking Medicare?
I'm not following, Your Honor, I apologize.
Okay,
So, it looks like my 15 minutes is up.
okay, thank you.
Thank you.
May it please the court, Michael Cook on behalf of the defendant, appellee Michael Mason. And I will mention that I do appreciate the support of the Hazlitt students this morning. The issues in this case concern damages in the new opt-out era of the No-Fault Act. Medicare is prerequisite to opting out of coverage for allowable expenses under the Act. I think the intent there is obvious. Drivers forego one for the other. The plaintiff's argument that you heard today is that the legislature didn't intend that those who opt out actually use the Medicare. They would resurrect, for anyone over 65, the problems that the No-Fault Act was meant to fix: long delays and lack of assured payment for medical expenses. If that were the intent, and this was touched on during the start of this argument, if that were the intent, the legislature could have provided for anyone to opt out, regardless whether or not they had Medicare, but it didn't. The plaintiff's argument also leads to what I believe is a trap for the unwary. If mitigation weren't required, and to be sure, it is required, but if it weren't, a driver could opt out, be injured in an accident, be convinced to forego their Medicare, and then be stuck with the medical bills if their tort action isn't successful or isn't successful enough. That trap disappears if the plaintiff mitigates their damages in the way I think the legislature plainly intended, using the Medicare. For the second issue is basically a walk through three statutes, and I think the plain terms of those statutes lead to the fee schedule applying to allowable expense damages in a third-party action like this. I think it's really important for that issue that the legislature didn't carve out third-party action and say broadly economic damages. It used a specific term, allowable expenses, and that term has very specific limitations under the No-Fault Act. Most primary here is the fee schedule. The legislature certainly could have expressly referenced the fee schedule in Section 3135, but it didn't have to. There are many ways that the legislature could incorporate the fee schedule. And I think here it did one. It incorporated the fee schedule by using the term that it is subject to, that is allowable expenses.
Mr. Cook, can you help me understand this more fully, again, on the mitigation of damages claim? Let's say that Mr. Canty had gone to a provider who accepted Medicare. Medicare was billed, Medicare paid because of the existence, it was payable because of the existence of a liability policy, even though he had opted out of it as a first party. Excuse me. They get a lien, right, on what they paid by, they issue the letter as a matter of course. So then, let's say Mr. Canty is successful against your client, and gets, I don't know, $100,000, and because Medicare paid and asserted a lien, that what Medicare paid is not considered a collateral source to reduce the judgment against your client, correct?
That's correct.
Okay, so you, in theory, would never sort of get the benefit of Medicare having paid his medical costs. It wouldn't reduce your client's liability. Medicare would get reimbursed out of what plaintiff, in fact, recovered, correct? Because they had asserted a lien?
I don't think it's true that we don't get the benefit of them using Medicare, and I think that's an important facet what Ann Derry touched on, in particular related to Medicare, is that its rates tend to be lower than the billed amount, right? So the plaintiff is recovering what was paid. The amount paid, Medicare has a lien for, so we would get the benefit in that instance. And that is part of the cost containment function, I think, of the new enactment of the No Fault Act, right? And how they kind of revised it, focused on containing costs.
But the judgment against your client would not be reduced by what Medicare paid
On that back end part of it.
on that back end?
Yes.
Okay.
It is significant as it goes towards.
So, and because it wouldn't get reduced, you're also then, in the context of trial, not able to introduce evidence that the medical costs are covered by Medicare, correct?
I don't think it's an issue of introducing costs covered by Medicare. I think it's an issue of introducing the amount paid, because the amount paid is what sets the compensatory damages award.
Okay.
And I think I've cited a couple of cases on that. Alt is one where it was the plaintiff presented the medical bill that he had paid or the amount that he had actually paid, and the court expressed it in terms of the amount you can recover is your reasonable and necessary outlay, the amount that you actually paid. In McCauley, this court, again, addressing compensatory damages, expressed it in terms of you're allowed to recover the amount of the loss, the plaintiff cannot make a profit, so how much is paid is the amount of the compensatory damage that you're seeking. So that's how it would be the amount paid. It wouldn't be, and I get that this sort of bleeds into, some people get confused, I think, with the collateral source rule. This is not a collateral source argument. Collateral source argument, if you look at Tebow versus Havlick, I think it's expressed there. The argument, what the common law collateral source rule does is I can't go into court and say, well, because Medicare paid, they have no damages. They've been made whole. That's not even something they can claim. Collateral source rule precludes that argument. And that's not the argument we're making. We're just making the argument you will be limited to the amount that's actually paid for it. And that's why if you don't submit it to Medicare, you're not mitigating the damages by using that coverage.
And so am I correct in understanding that the Greer case and the other one I can't pronounce, it starts with a Z, where the insurer or Medicare paid, or the plaintiff was billed more and Medicare asserted a lien, or the insurer asserted a lien for less than that they only get the offset of the lien, right? Is the difference here that there actually was a lien? Like your point is being, that all works if they actually submit for Medicare and there's a lien. But if those benefits are payable and there's no lien asserted, then there's nothing that prevents them from being a collateral source, basically.
And that's part of my point on how it's a trap for the unwary. Because if they don't submit to Medicare and they do get to that back end part of it, where you're applying the collateral source rule or 3109, they're going to see a reduction at that point for the amount that is payable. And I think that is, in a cohesive, efficient system, they've used their Medicare coverage, Medicare is paid, those bills are taken care of, Medicare has a lien, and if they recover, Medicare gets paid out of that lien. That's the efficient system. If they don't use their Medicare coverage, they end up, I think, in a very dangerous position where either they're unsuccessful in their tort action and they have no coverage, they're just stuck with those bills at that point, or they end up being faced with those collateral source reductions for what was payable.
But
And
no,
that's going to be
nothing
reduced
asserted.
at that point too. So I do think, I understand that as it relates to Mr. Canty, he's arguing against the mitigation in this case. I think on the broad picture, on the whole, in terms of making sure the system works for people injured in car accidents, it is important that they do use that coverage so that they don't get stuck in those consequences afterwards. I think it becomes very messy at that point.
And am I correct in understanding what the Court of Appeals says in this case is that there's still disputes of whether or not some of the medical services were provided by a provider that bills Medicare? There's also a question of whether some, in fact, were billed against Medicare. And the Court of Appeals is saying, in those circumstances, you have to, this issue of mitigating is at issue, but there may be some providers who didn't accept Medicare and therefore didn't bill it, and the plaintiff is able to argue that that those services and the amount paid were reasonable and necessary for his care.
I think you're correct in understanding the Court of Appeals' opinion. As it relates to the providers who accept Medicare, I do think there is, as you indicated before, some work to do. When we go back below, the record in this case is not voluminous. I do think there is work to find out for the providers who do accept Medicare, confirming that they didn't submit. If they did submit, and I don't think there's any indication they actually did, what happened with that, the reason for the rejection. Some of that needs to be worked out. As it relates to the providers who do not accept Medicare, the Court of Appeals did say that's subject to a reasonableness argument. I push back on that a little bit and say the plaintiff should have produced evidence of why he went to. This is a summary disposition motion. I think it would be his burden to produce evidence showing a question of fact on why it was reasonable for him to go to these others. If you look at the Toussaint, this court's opinion in Toussaint versus Allstate, it kind of touches on those same concepts within the context of a coordinated policy under the former. And it did say, if they were referred to a non-Medicare provider because for some reason there's no one who accepted Medicare who would provide that service, if there was some reason, then maybe we would allow you to go to that. Ultimately, the court said, if you have that coordinated policy, you have to use it. In that case, it was an HMO. You had to go with your HMO-approved providers. But it did have language saying, if you do have a good reason for going elsewhere, then maybe you can do that. And I think it's the same situation here. The only point I push back on that is to say that they didn't really produce anything in response to summary disposition to say why. And
But
create
you're
an
not
issue of fact.
cross-appealing on that issue,
I didn't
right?
file a
It's
cross-appeal,
going-
no.
Okay.
Counsel, I want to just turn back to, I guess, sort of the purpose of the statute and the question I asked Brother Counsel. Why would we treat first-party actions and third-party actions differently? I think your answer is we don't. But I just wanted to give you a chance to respond to that.
Sure. I think you anticipated my answer. I will say, in terms of treating them the same, and these are policy judgments, right? And I think Judge Mariani touched on, hey, there could be good reasons to treat them differently. There could be good reasons, I'll say, to treat them the same. And I think that's reflected in the cost containment function of it, and that being a primary motivating force of the 2019 reforms. There's also a cohesive nature of it, right? If you're going to have the PIP benefits be subject to the fee schedule and the caps, it seems like it's okay to go ahead and contain the costs on the third-party liability part of it because everyone's still required to purchase coverage for that too. So I do think that the cost containment aspect of the legislation, if you're thinking about policy and why would they do this, that's why you would treat them the same.
So, okay, so I think we remember when the bill was debated and the goals, of no-fault reform. That was, I think, fairly well stated and stated in many places. So, assuming I agree with that, then we look to the statute, and it does seem like your way to get to the answer is more convoluted than plaintiff's way to get to the answer. One just looks at the words and says, well, 3107 to 3110. I think you're creating an argument that has to incorporate a lot, including an entire chapter within a section or within a phrase. So I want to give you a chance to respond to that because I understand that we have this. I'm wondering what's ambiguous here about the words that would say, oh, great, I can go look at purpose, because I am someone who's written about that. I do think purpose can inform our decision-making, but usually it has to mean something is not clear from the words in front of us.
Sure. And so on that, I do think it's important to know how the legislature incorporated the fee schedule for allowable expenses. And that is they inserted that language at the start of 3107 subsection 1. That's how they made the fee schedule apply to allowable expenses. What they didn't do is go into the carve-out for third-party actions and limit it down to 31071A. And they did that at several points throughout that amending language or amending act. They specifically referenced 31071A. I'm gonna trip over my number soup there. They put that in at several different provisions. So they knew how to, and they certainly did it. And the fact that they didn't do that in the carve-out for third-party actions, I think is truly significant. They left in there the broad reference to 3107, which then is where they amended it to make sure that the fee schedules applied to allowable expenses. So I think, again, there's a lot of different ways they could do this, right? There's a lot of different ways that they could have been way more clear than they were. They always are in hindsight. But that doesn't mean that they didn't do it. I think the way it's structured now, it does involve a walk through the statutes, but I also think that's a common way for legislatures to act when they are adopting a specific provision and not trying to restate everything. Let the other statute do the work, and I think that's what they did here.
Thank you.
If there are no further questions, I'm really close to the end of my time, so I will thank you, ask you, of course, we're asking you to either deny leave or affirm the Court of Appeals. Thank you very much.
Thank you. The case will be submitted, and the court stands adjourned.